Hello and welcome to this crash course for NCA Administrative Law exam. This is for students who are going to sit for their exam in upcoming months. My name is Maneet. I recently completed my NCA requirement, and when I was writing my administrative law, I realized there were a lot of friends of mine and colleagues of mine who were confused, as confused as I was about the bigger picture of the administrative law. And that's exactly what the very first page of the syllabus talks about on the NCA website, that this is about the big picture. If you do not understand that big picture, you will not be able to pass the exam. But in my experience, there are two main things that you need to know to be able to pass the exam fairly easily, right? Fairly in an easy manner. If you break it down in two buckets, the requirements, the very first bucket would be about the case laws. If you have read enough case laws that are there, I came up with about 20-25 case laws that are important. If you can read them, you will be able to locate that whatever question that comes into the exam, you will be able to locate back to the case law that you have read before. And it will be much more easier for you to be able to navigate to the right answer. Because most of the times, as soon as you read the question, you will be making the decision in next few seconds that what is the legal concept that I am being tested on. Where do I need to apply all that I understand from the administrative law? What do exactly I need to apply here? So if you do not understand that, it will be okay, now this is a real life thing. There was one time where administrative law exam had only one question, 100 marks, one question. Now if you have made a mistake over there, that you forgot to write the procedural fairness and you only covered the substantive review, or you forgot to write the substantive review because you could not figure out that this is about it or not, then done. That's the end of the exam. You're done with it. You will have to write it again because there was only one chance, there was only one question that was there in the exam, and you did not understand it very well. Because if there are 5 or 6, you may be able to manage, but if it is only 1 or 2 or 3 questions, it is really hard for people who do not understand the big picture, right? So that's the reason why I'm keep on repeating the word big picture. Now coming to the second bucket. The second bucket is about having to have that layout in your head, that how do you approach step by step each question. If you do not have that layout in your head, you are bound to miss out some of the steps which are essential for you to be able to make the decision, and then you will lose your marks fairly over there, which is again can be really devastating at that point of time. So these are two things. You need to have a structure, you need to understand enough case laws, and that's where, in my understanding, the big picture will cover most of the things. Now let's take this further. Let's break it down. So since it's a crash course, I will only break it down and try to cover what is important. Now administrative law, there are two main parties here. There is one party that is executing the law. Executing, that's the executive branch, right? Where you and I are dealing with a body, where we are dealing with an administrative body. So this could be, since you are a foreign trained lawyer, you may have dealt with and applied for an application for visa, for your student visa, or maybe your permanent residency, and so on and so forth in Canada. Immigration and Refugee Board is an administrative body. Similarly, we have other professional bodies related to chartered accountant and lawyers, and there will be others. And then we can have environmental bodies as well. These are again administrative ones. These bodies are given the power to apply to, how to say that, the to implement the law, right? And they get the power from the statutes, mostly from statutes. These statutes are enacted by the provincial governments and the parliaments, and it could be possible that the parliament has enacted a statute that enables an environmental body, right, that creates an environmental body, environmental administrative body, where they give the power to this administrative body to fine companies and approve their applications and so on and so forth. These are the power that are delegated to these administrative bodies. So there are only two parties here, right? One that is giving the power, the other one that is executing the power, executing on the basis of the power. If you keep this in mind for a while and move further, right, we have 3 sections in the administrative law, and these sections are here. As I already covered, what you need to pass the exam. I'll cover this in details once again, but these are the 3 sections, the 3 major sections where you will be making a quick decision as soon as you read the question. You read the question and then you come back with a decision that, is this question about procedural fairness? Is this question about substantive review? Or is this about challenging the administrative decision? More likely, if it is about the third one, it will be like, where does this need to go? Is it the federal body? Is it the provincial body? Do they have power to challenge the administrative decisions, so on and so forth? We'll talk about that later on. So the very first one is the procedural fairness. Okay, how do you come to a conclusion that a question is in fact about the procedural fairness and not about the substantive review? Because that's where the main confusion would arise, right? So I came up with this list of keywords where you can certainly come to a point in a certain manner that, yeah, this is about the procedural fairness. That's what it is. This question is talking about. So, like, the focus on the how. Does this question describe how the administrative decision was made rather than what the decision itself was? The reason being, for the procedural fairness question, it doesn't matter what the outcome was. So, for example, if you have applied for a visa application, right, for your student visa, and the application was denied, it doesn't matter the application was denied. Even if the outcome of the outcome of your application was still denial, but the procedural fairness was missing, you can still say that because there was a lack of procedural fairness, I need this application to be reviewed. So there is no concern, there is no point of there is no outcome in the procedural fairness. It doesn't matter over there. But when it comes to the outcome, when it is about the outcome, it is more likely, not more likely, this is 100% the substantive review. Now that's one thing. Now, what are the other things, what are the other keywords that would arise in a question? Like lack of opportunity, not given a chance to speak, no notice or hearing, the notice wasn't there, the person who applied wasn't told, not informed of the case against them, they just didn't know the case that they have to meet. Denial, denied legal representation, counsel unable to present evidences, insufficient time to prepare, report not disclosed, so on and so forth. If you have these, this is about procedural fairness. And all the things that I just said, there is a case law related to that, and then we can point a case law towards it. And then the other one is bias impartiality. For example, decision makers showed prejudice, comments indicated a close-minded, like in Baker v. Canada. Conflict of interest, the person who was applying had some grudge with the person who applied, who was deciding had some grudge with the person who applied. Involvement of preliminary investigation, that's again we'll talk about later on. Lack of independence. Okay, so that's one. Then reason for decision is missing. There's no decision, no reason given for the decision. If somebody has approved an application, you obviously wouldn't go back and apply for the review because that's what you wanted. But if the application was rejected and the reason was missing, you obviously want to apply and see that what was the reason that you did, you rejected my application. I want to know that. That's about the procedural fairness. So inadequate reason is also one of the reasons that it is about the procedural fairness. Now there are questions where both of the elements are present from the substantive review as well from procedural fairness. We'll talk about it later on. And then we have one concept that is duty to consult if there was no consultation made, specifically for the Aboriginal indigenous communities. At that point of time, duty to consult does arise, and the decision can be challenged over there on the basis of procedural fairness. Now let's talk about the second thing, which is on the basis of the outcome and the merit, right? The focus is on what. If you remember, the focus was on how the decision was made. Now this is about what was the decision. So does the question challenge the content or outcome of the decision list itself? So the list that I'm talking about, I will share with you, maybe in the description. If there was an error in law, right? Decision is based on the misinterpretation of the statutes or law. Acted outside of jurisdiction. Incorrect application of legal principle. Now that's the error in law. Error in fact is going to be a decision made on factual error. And then no evidence to support the findings. The findings, there is no evidence, but somehow some facts are written without any findings. Okay, then we have error in discretion. For example, decision was unreasonable, abuse of power, failed to consider relevant information, consider irrelevant factors, and so on and so forth. Similarly, we have application for standard of review. Does the question ask you to determine if the decision was reasonable or correct? If that's the thing, you have, this is about the standard of review, because that's what the two things are, right? Those are the two determinations that you have to make during the standard of review, that if it is about the reasonableness or is it about the correctness. If the question mentions Vavilov or Dunsmuir case, Dunsmuir it wouldn't, most likely, but it will be mentioning Vavilov v. Canada. In that scenario, you have to talk about the standard of review, and standard of review will further elaborate into these 2 points, right? Like one will be, is it about the reasonableness or is it about the correctness of the decision? So that's how you will be deciding. And I do have this list in front of me. If you read this, where you can decide and come to a conclusion that this question is about reasonableness or correctness from the standard of review, or is it about the procedural fairness? So these are the keywords that are there for us. Okay, going further. So I hope so far this is clear. Now we have the identification part. Let me go back and share this one. So what are the procedural obligations and what are its sources, right? So the very first thing that you will be identifying is, we can actually talk about this later on, and we can talk about how you need to make a decision. Okay, this one is okay. So once you read a question and you have come to a conclusion, let's say you have come to the conclusion that this question is about procedural fairness, because the question is the question which has been asked is about how the procedure was followed, right? Like how the procedure was not followed or followed on that regards, or on the keywords that I've shared. So if you have come to the conclusion that this is about the procedural fairness, this is the flow that you have to follow. The very first step is to determine if any procedural obligation or duty of procedural fairness is owed to an individual in the scenario. This involves checking of the stated source of procedural obligation and prescribes a procedure to be followed. Now, it could be possible that this is a body that just does not comes under the comes under where they have to follow the procedural fairness. So you first of all you have to come to that conclusion, right? You have to decide that first. So the potential source is enabling statute. The primary place to look for is the statute. As I said, the primary source for the power will be the statutes. Most legislation creating administrative decision making duties will also outline the required procedure. If the question mentions an enabling statute, it will likely detail the procedural obligation. So if it's an elaborated question, the question is, let's say, 1 page long, it has sections inside it. You will be able to find in one of these sections that I mentioned that what is the procedural obligation on the administrative body. And if it is there, well and good, you can actually quote that as per the statute, this is from this section, this is the procedural obligation on the administrative body where they have to follow the procedure. They did not, and hence this is the application that is coming for the review and so on and so forth. You can apply to this directly. This is plain and simple and straightforward, right? Now there are other things. The delegation of the legislation, right? Like this one where the enabling statute is silent, but then subordinate or delegated legislation. The legislature may delegate power to an agency to enact regulation or rule for procedural requirements. Now, instead of the from the act itself, there wasn't any mention of the procedural obligation, but then there are rules within the administrative body where they have enacted these rules, and those rules again will become the second source for you to look for. And again, this will be given into the question itself. This won't be something that you have to look from outside. This will be something which will be given into the question itself, most likely. Again, now the third one is the policy and guidelines. Public authorities often issue non-binding guidelines and policies regarding the procedural aspects. Again, this is again part of the administrative bodies, and these are the guidelines that comes from the public authorities, often given into the website of the administrative bodies and so on and so forth. You will be able to find, again, if it is something which is a made up administrative body during the exam, this will be given into the question. Now, general procedure and statutes. Some Canadian jurisdictions have these setting standards and procedure for decision making. Example, Ontario Statutory Power Protection Act. That's one thing which again will be given into the question. So all these ones, 1, 2, 3, 4, the 4, you do not have to look anywhere, and this will be given into the question, because you would not have all the acts and statutes that there are in Canada with you at the time of question, right? So this will be given to you. All you need to do is read the question carefully and then find out where the source is. That's it. And then you will be applying to that rule or the statute or the law, and then you will be replying that okay, this is the one that where the procedural obligation is coming from. If you do not have in any of the four that are mentioned over here, then we come to the common law, and most likely during your exam common law will be the source for your procedural obligation. Because if you think about it, if it's just a 2 or 3 or 4 marks, 5, 10 maybe marks question, the answer will be right there into the question. You just have to point towards the procedural obligation, that this is where the procedural obligation is coming from. It's quite simple, right? But if let's say it's a 20 marks question or 10, 15, 20 marks question, it is most likely to be a common law source. So if procedural obligation are not provided for in the above sources, as I said, or are inadequate, common law principles of natural justice may fill the gap. We'll talk about the common law here, and then common law we have certain, again further sections we'll talk about it later on. And again, this applies where the decision for the Charter of Rights and Freedom, we are only talking about the section 7 here, of life, liberty and security of the person, and mandates adherence to principles of fundamental justice. Now this one will be very specific to the scenario that is given into the question. And as I said, if you have read enough case laws, you will be able to actually point out which Charter of Right and Freedom related case law that the question is talking about for the section 7, and you will be able to point it out to the case law. Similarly, for the Bill of Rights, Canadian Bill of Rights, again only talking about section 1A and 2E. That's it. You don't have to worry about any other section here, just these two. And applies to the federal government bodies, prescribes fundamental justice and protection of life, liberty, security of person, property. And if you have noticed that the property is also mentioned in the Canadian Bill of Rights, which is not mentioned in the Charter of Rights in section 7. So you can see that the your economic interest are also mentioned over here. And the right to the fair hearing in the determination of rights and obligation. Right, so we will talk about how to apply them. These one are quite simple and straight. You don't have to worry about them. They will be, again as I said, will not be as how many say these questions will be not too much in the weightage compared to the ones for the common laws and Charter of Rights and Canadian Bill of Rights. Okay, so that's one. Once you have determined that, the sources, you will be applying, you will be determining if the procedural obligation trigger apply. That's where everything starts. Once a source is identified, consider what triggers the procedural obligation, right? If it is a common law, as I said, most likely your question will be about common law sources. So common law triggers are these. So the common law triggers are coming from this case law, the Knight three-pronged doctrine. Three-pronged doctrine applies if the nature of the decision, the relation between the party and individual, and the effect of the decision on the individual rights suggest a duty to act fairly. You have to read this case law in details, and you will be able to understand why the common law triggers here. We can actually cover this in the later videos. Today I'm just covering that what we are going to cover step by step. Again, legitimate expectation. This is how it has been done in the past, and this is how I was expecting it will be done in the future when I apply and when I'm applying, but it did not. I had legitimate expectation that this is how the process was supposed to be, but it was not. So that's where the common law trigger will apply, because the rules apply to everyone in a similar fashion. It cannot be different for everyone. So that's where this trigger is coming from. So you can see arises if a promise or representation was made by a delegate or an individual to proceed in a certain fashion and an individual relied on it. This usually applies to procedural fairness, not substantive rights. Again, this is specifically for procedural fairness and not substantive right, and we'll talk about why this is mentioned over there. Now, other triggers are legislative decisions and emergencies are general exceptions where common law procedural fairness rules may not trigger. Constitutional duty to consult indigenous people is also a trigger. Okay, now the step 3 is, once you have decided that which one of the common law triggers that applies here, then we can go for, and again, like there can be more trigger, we'll talk about that later on. Assess the content of procedural obligation, right to be heard, and unbiased decision maker. So you have to assess the content of the procedural obligation. Like if a duty of procedural fairness is triggered, the next step is to examine its specific content. Like this is where we will talk about the Baker 5. Baker 5 is coming from Baker case law, and 5 is like are the things that we have to take care of here. Procedural Baker factors are, so Baker 5 factors are the precise content of the procedural rules varies. Consider the nature of the decision and the process followed, the nature of statutory scheme and its terms, the importance of the decision to the affected party, the legitimate expectation, as we have already covered before, and the choice of procedure made by the agency itself. So these are the Baker 5. These are the Baker 5 factors that come into the play when it comes to common law, charter, or Bill of Rights. As I said, if it is not from the statute, then it is from these 3. And then we have to go one by one, step by step, and apply these to each question, and then come to this conclusion that, okay, first of all, does trigger apply? Then you come to the Baker 5, and then you see that what are the further, content to the procedural obligations that apply here. Is it just one? It could be 1, it could be 2, it could be 3, it could be all 5. So you have to basically come to the conclusion, out of these 5, what are the factors, what are the factors that apply to my case that is given in my question. Then we will be talking about specific procedural entitlements like right to be heard, you should be given proper notice, so on and so forth. And again, don't worry about these. We will cover one by one when we cover the case laws. And then later on, we talk about the step 5, which is the standard of review. Again, even if a question that is about the procedural fairness, it could be possible later on it is about the standard of review as well. They could ask that, for the standard of review, what do you think, which standard of review would apply here? Is it the reasonableness or is it the correctness? And then that's where we will apply the Vavilov framework. And the Vavilov framework will talk about the presumption of the reasonableness, which basically means that there will be a presumption that reasonableness is the standard of review to start with. And why it is not, we will come to the conclusion later on, why the presumption of reasonableness is not the correct one here and why it should be correctness. So we will come to that once we cover the Vavilov framework during our short, this crash course. Again, so that's it. So once you have done this, you have covered your answer thoroughly. And on the basis of this, you will be able to at least make, you have made sure that you have covered all the aspects of a question, and you have covered all that is being asked to you during the examination. So what we will do next is we will cover the case laws one by one from the common law, and then we will see that how they are applied. We will also cover some questions too, to be able to get some practice, and that will give you enough confidence later on. So I'm planning to make about 5 to 6 videos, and I guess in next 6 videos you will have enough content and enough knowledge about the administrative law. I believe with this framework that I am talking about and with all the keywords that I was talking about, you will be able to navigate your answer correctly. This is it for today. Thank you very much. And if you have any question, you can ask me in the comments. Thank you.